All right, so as I said, today we're talking about cross-examination, right? Last class, if you recall, we went through a direct examination where you call your witness, right? And your witness is the star, you put them on, you just ask open-ended questions, who, what, when, where, why, how, and they tell their story, right? What they saw, what they observed. So once they do that, after each time a witness goes, the other party gets to cross-examine them, right? So cross-examination is this next step. After they're done, the party who called the witness is done questioning them, then you can engage in cross-examination. So cross-examination is the opposite of direct examination in terms of the rules that govern it. So remember we talked about direct examination, you cannot use leading questions. Right? I mean, at the beginning you might be able to use one or two, but nothing important, right? Cross-examination, all it is leading questions, right? So you go from having the witness be the star during direct examination, on cross-examination, you're the star. The jury should be looking at you. That being said, cross-examination has to be, it's called within the scope of direct examination. So if we look at Federal Rule of Evidence 611B, cross-examination should not go beyond the subject matter of the direct examination in matters affecting the witness's credibility. That being said, in criminal trials especially, you have a right to a defense, right? So if the prosecution doesn't go down a certain avenue or doesn't explore certain areas, you may inquire into those additional matters within the discretion of the judge. But you have to switch then to open-ended questions. And that's where a lot of things get messed up, because suddenly you're making that witness your own. On cross-examination, the whole point is you're controlling that witness, right? Basically, you're telling the story, and the witness is just there to say yes to every question that you have. Right, so you're telling this story. If you go into a matter that wasn't covered in the direct examination, then you have to basically get the judge's permission and then ask open-ended questions, right? Who, what, when, where, why, and how. The problem is if you have an adverse witness, you're going against them, right? And suddenly now they get to talk, and now they're the star. Well, that can do a lot of damage to your case, right? So best rule of thumb is never go beyond the scope of the direct examination unless you're going down an alley where you know there's gonna be some damage, right? They're gonna do some damage to you, but it's a really important avenue to pursue. So that being said, we have to think across examination and direct examination, to be fair, of the jury's perspective, right? So court, as I've said before, is very, very boring, right? Direct examinations, by their nature, tend to be boring. Cross-examinations, that's where we see, at least in TV, people become feisty, right? And try to fight with each other, and the lawyers get, they make their grand puffery, and it's just, it is what it is. So remember, jurors are cattle. I mean, that's basically all they are. They are meat with eyes. So they will generally follow like TV shows like this and think, oh, cross-examination, awesome, like this is gonna be, an intense thing, which actually works to your benefit, at least towards the beginning of the trial, right? Because at this point, as soon as the judge says, counsel, you may cross-examine the witness, the jurors' interests go through the roof, right? Because what they expect is a high drama and a mental, fast-paced duel, right? You versus the witness. That's what they expect. That being said, this expectation of this duel, right, has to be tempered by two considerations. First, jurors do not like unwarranted aggression in the courtroom. Right? So basically, a lawyer shouldn't, I should say, they could, I mean, they shouldn't, present in such a way that they seem aggressive or like they're attacking the witness. Unless, and here's the big unless, they have a really, really good reason to be tough on the witness. One that the jury will understand, one that the jury will kind of go along with, right? And we also look for, if we're going to attack the witness, we're going to look for things that we can use to what's called impeach them. So impeachment is, we'll have a whole day on it, but impeachment is basically, you just said something that I know is not true because you said in another statement, like a piece of paper or a recording, whatever, something completely different. So I, as a cross-examining attorney, get to go up there and say, so you just said this. You swore an affidavit. Right? You swore to tell the truth. You swore to tell the whole truth. And you swore to tell anything but the truth, right? Well, in this affidavit, you said, and I'll read it out loud, blah, 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 blah. Right? So like you can start to build, like if they're lying, you can start to build a little bit more aggression. Right? But even in that instance, it's not like, you said this. No, it's, you said this, and this is what the paper says. Tell me which one's true. Right? So it's kind of like a strict father figure. That's about as high as you want to go in terms of cross-examining. But again, just like direct examination is a conversation, cross-examination should be a conversation as well. A conversation that you control. Right? So the next thing I want to say is when it comes to cross-examination, right? The jurors look at you and they look at the witness. Right? And you're dueling back and forth because you're wanting them to say yes to your questions and they're probably trying to say no or trying to explain things regarding your questions, right? So, what happens if the lawyer and the witness tie, right? In the jury's minds, like they're both really, well, they both made really good points and you know, I'm not sure who it goes to. Jurors generally will side, if it's a tie, with the witness, right? Because the idea is juries think lawyers are supposed to be courtroom experts, right? We should know the ins and outs. We should be able to control people. We should be able to get what information we want from people, etc. Even if that's not necessarily true or you know, even if it's very much fictionalized, that's what juries think. So what they think is you just went head to head with this witness and the witness either won, which is really bad for you, or two, tied, right? Like they matched you. You didn't get what you wanted out of them, but they didn't say what they wanted to say. They're going to go with the witness, right? Because you're the expert and you couldn't get the job done. So that means the witness is probably telling the truth, right? So that's kind of the rationale behind when we think of how we conduct ourselves during cross-examination, right? And it's a good thing to keep in mind because we are supposed to be experts, right? And how to manipulate, and not necessarily in the negative connotation, but how to control people, how to control lines of questioning, how to build a case, how to present evidence, etc. So the jury's response is, it makes sense. If we continue along talking about the jury, juries, like all persons, soon forget most of the details of any cross-examination. The actual words of specific questions and answers, right? So you're cross-examining, you're telling your story, right? The story you want to tell. Juries are going to forget what you said and the yes or no what they said, right? They'll remember some, like maybe key parts, but generally speaking, they're going to forget it. So that kind of brings us to how we hold ourselves, how we hold our posture, how we come across to the jury, because that's what the jury will remember. The jury will remember that really nice lawyer or that really professional lawyer. They won't remember this back and forth, right, because I mean, the answers that you're getting in cross-examination will generally always be yes, right? If you design them correctly, they'll always be yes, or if you need to know, they'll be no. So they're not going to remember that. Like, they said yes a bunch of times, that's all I remember. But if you were the nice lawyer, or if you were the professional lawyer, the well-spoken lawyer, or the well-dressed lawyer, etc., that's what they remember, right? So juries, they remember how you ask your questions, right? So it gets tricky because you want to get caught up in the courtroom drama, right? Like, you go on cross-examination, like, you know you can unleash fury, right? And just be like, just pound them away. It's easy to get lost in that mentality, even if you're controlling yourself. Because you have to think, I'm not talking to this witness, like, at all, right? Even though I'm sitting there, like, staring at them and pointing or whatever, I'm not actually talking to them. I'm talking to the jury, right? Because I'm the one telling the story now. I'm talking to the jury. So they're going to see your tone of voice, how you control yourself, right? How you ask questions, and your body language. They're going to look at all of that, and that's what they're going to remember, because you're talking to them, not the witness. I mean, that's at least what you should think in your head, is I'm talking to the jury. So if I go up to a witness and I start pounding on the table, right, raining down hellfire, if it's not warranted, the jury's going to feel personally attacked, right? Because I'm not talking to them. I'm looking at the jury the whole time, right? And this person's just agreeing with what I'm saying. Like, that's all they're there for. That's all I care about, is they agree with what I say. So if you come down with a hellfire, you don't have a good reason, you're going to turn off jurors real quick, right? Because you would think, like, jurors would like the snarky lawyer, right? The quick-witted lawyer. They do, for about 10 seconds. Then after that, it's, okay, this guy's not just, he's an asshole, right? He's not a good guy. So they remember, how did you ask your questions, right? Again, if we're cross-examining, and this also depends on who the witness is, right? If I'm cross-examining a widow, right? We're in a civil case. I'm cross-examining a widow whose car caught fire, and she was able to escape the vehicle, but her husband wasn't, right? And her husband burned to death in the car. It's a horrible story. So you have a widow up here, and let's say I represent the insurance company. I'm saying, nope, you were smoking in it or something like that, right? So I represent the insurance company. If I'm talking to the widow, so the widow's here, I'm talking to the widow, and we know she's a widow because we just had the direct examination, and I guarantee you she cried on direct examination. Your goal is to make her not cry, right? Because you have a widow. Am I going to come up to a widow and be like, so, when you were driving this vehicle, you were smoking, weren't you? And you know the dangers of the smoking, and then you start to accuse them, right? Or you start to come across as, I'm attacking a woman who literally just lost her husband, right? So that's what the jury's going to remember, is like, whoa, what the hell? But if you present a different tone of voice, right, and you're very apologetic, you're very sympathetic, you can still get the answer you want. You might actually be more likely to get the answer that you want, right, from the witness, because the witness suddenly trusts you, right? Because at first they're thinking, I'm the bad guy, right? The guy's cross-examining them, I'm the bad guy, which I am. But if you can build their trust, their confidence in you, then what you can do is amazing, right? So again, you have the approach of I'm going to scream and point and pound. You're not doing that with the widow. The widow is, Mrs. Smith, I'm really sorry for your loss. I'm just going to ask you a couple questions just to clarify. Is that all right with you? Okay. So you're a smoker, right? Okay. And you've been smoking for quite a long time. In fact, on the day of the fire, you were smoking in the vehicle, right? Suddenly it's like I'm like trying to be a sympathetic, uplifting, just like an intimate conversation. Because now most courtrooms are mic'd everywhere. So I'm having an intimate conversation with somebody. Because now suddenly the jury thinks, oh wow, that lawyer really cares. Or like that really sympathetic, and then you get the information you want out. All right, and then in closing, the closing arguments, you can fire and scream and hellstorm, and that's fine. So you could be like, and the widow said she smoked that day, right? That's fun at that point. But when you're dealing with a person, you have to remember you're dealing with a person, right? And you have to have that soft touch. Also, body language is important. If you're slumped up, if most courtrooms have a podium, always ask the judge if you can move the podium, right? And it's called, and you ask the judge and you ask if you can walk about the well. The well is everything in front of the bar. The well freely, right? This is because if you get up there and you have something, you have a podium, you're going to have papers, right? I guarantee you. If you don't have papers, right, or if you do, you'll also grab the sides of that podium. You'll lean in a little bit. It looks like you're lazy. You can't stand up, right? And the worst part is having the notes. Cross-examination, you might take a note or two on a notepad, especially for small trials. Like big trials, this can differ. But generally speaking, cross-examination should stem from direct examination and the facts that you know to be true, right? So there was a good lawyer once who said, if you are good at your job, all you have to, and you know, like, let's say you come into a courtroom completely blank, right? You know nothing about the case, nothing. And all you hear is one person's direct examination. If you're a good lawyer, you should be able to then immediately start cross-examining that same person, even though you have no clue what happened in the case. Right? So we kind of focus on what did they say, how do I shape it, how do I change it, how do I manipulate it in such a way that it's good for my side. Right? And again, we have different tones with different people. So with the widow, we're sympathetic. With the police officer, we're respectful. Right? You might hate cops, like I do, but you're respectful. Unless that one time where I made the cop cry, but that's a whole other story. Right? It really just depends on who is sitting there. And that's one thing that we always have to focus on, is this is just a game in storytelling and basically a big theatrical production. Right? So if you've ever seen the movie Chicago or seen the musical live Chicago, you know, at some point he basically says the attorney, Larry Flynn, basically says, this is just a stage, right? It's just a big production. And for cross-examination, that's all it is, right? I could give two shits less that her husband died. I don't fucking care. But suddenly, I have to act like I do, right? Or I have to pay homage to the officer. Officer, you know, thank you for doing everything that you've done during COVID. You know, I imagine it can't be easy on you and your family. So I'm going to ask you some questions. Right? It's just, you pay that little homage, that jury's going to like you. And that's kind of the whole point, is the jury will generally decide cases based upon their favorite lawyer. Right? And so that's kind of your goal, is to try to get in good with the jury. So again, when you're doing cross-examination, remember the jury has certain expectations. You should meet those expectations. You should understand their interests. You should create an impression upon the jury and evoke emotional response from the jury, right? So if I'm talking to the police officer and I'm saying, so, Officer Doe, Officer Doe, you patrol the Upper East End, isn't that correct? Yes. Now, the Easter Up End, or the, yeah, Up Eastern End, whatever you want to call it, it's a fairly affluent neighborhood, wouldn't you say? Yeah. Now, you've been patrolling it for 7 years, isn't that true? Yeah. And you've gotten to know most of the residents. Yeah. Most of the residents on the Upper East Side are white. Isn't that true? Well, I mean, not all of them, but no, oh no, okay, but the vast majority. Yes. Okay. Now, when you were driving, doing your patrol on Monday, January the 2nd, you observed my client walking down the sidewalk. Yes. My client didn't have any weapons on him, as you can see. No. He didn't try to duck and get out of your view. No. In fact, he just kept walking. Yeah. But you decided to stop him. Yeah. You just wanted to ask him some questions, right? Yeah. And you go through this and kind of build it out. And then you can end with the hammer, right? The one that will make the jury go, oh. And you'll say, Officer Doe, in fact, the only difference between my client walking down the street and another member of the Upper East Side walking down the street is that my client was black. Now, the jury's not gonna give a shit what he says, right? Because suddenly I'm just dropped the hammer. So you can build it up. You don't have to go in blazing. You can build it up, build it up, build it up, and then drop it. But the goal is to get an emotional response from the jury, right? If you can make a jury cry, like, you're gonna win the case. If you can make a juror get mad right in the face, sometimes the jurors will whisper to themselves or to each other. Pick up on that, right? So when you're in the courtroom, you have to not only be aware of the judge and the judge's role and rules, you not only have to be aware of the feelings, emotions, and the needs of your client, the feelings, emotions, and needs of the person you're cross-examining, but also the feelings and emotions and needs of the jury, right? And especially important cross-examination, because you control the story, right? They don't. You get to walk them down whatever path you want to go down. And I'm talking to the jury. I'll maybe angle myself. This is where the person sitting, I might angle myself in like a 45-degree angle. So I can say, Officer Doe, you have a history of stopping black men more than you do white men. Isn't that true? And I just looked at the jury the whole time. Just talk to them. They're going to presume, they might listen to the witness, they might not. Most of them aren't. Most of them are going to presume that if I just said that, it's true. Right? Because I'm looking at them, I'm talking to them directly, and I'm carrying myself in such a way where I have the confidence. Right? And that's one big thing you want to have, is you want to own that courtroom. You want to walk in and have people notice you. You know how some people just have this kind of magnetism about them, right? Where you might be in the middle of a conversation, somebody walks in that you don't know, but everybody kind of stops and looks because that person has a presence. You have to develop that presence, right? And that comes from confidence. So you can be a confident lawyer, but you can also be compassionate at the same time. Right? So you're confident in what you're doing, but I understand my heart goes out to you. So again, it is a production in a way, but it's really a role in psychology and understanding who your audience is. So how do you structure a cross-examination? Well, there are generally three things that you should try to accomplish, okay? And they occur in the following order. The first thing you want to try to accomplish during cross-examination is you want to bring out facts that are helpful for your side. Right, so if we go back to the case of the widow, right, who is the defense is saying was smoking in the car. If I'm on doing a direct examination, I have a choice to make, right? So I can either say, you've been a smoker for so many years, right? And just kind of take the sting out of it, right? So when I come up, they're just gonna be like, yeah, she already said that on earlier. Or you might go, I don't know if the defense knows this, right? Because if I suddenly say you're a smoker and the defense didn't know that, whoa. Suddenly that defense is changing and it's going to not look good. You just open the door and we're gonna walk right through it, right? So our goal is to bring out facts that are helpful for your side. So let's say in terms of our widow, direct examination, they didn't reference the fact that Mrs. Doe smokes. I'm gonna hammer home the fact that Mrs. Doe smokes. Right, and try to do it in such a way that the jury reaches a natural conclusion that she was the one smoking in the vehicle. Right, and it was ultimately her fault as to why her husband died. So that's kind of how we progress, right? We want facts that are good for our side. So we start by bringing out helpful information, right? Either by one, emphasizing something the witness has already testified about on direct examination, or by bringing new facts that the witness knows but didn't disclose. Right, so we talked about the non-disclosure, emphasizing certain facts. Right, again, you have the widow on the stand. Ms. Doe, again, I'm sorry for your loss. I heard you say earlier that you've been a smoker for 18 years, right? And on the day of the horrible tragedy, you were smoking, right? In fact, you were smoking in the vehicle, right? Because you're just reiterating what they've said, right? On direct, and like you said on direct, and then you can kind of go down your own path. Now, because bringing out helpful information is not an attack on the witness, that's kind of what we strive for, right? So we don't want to attack the witness. We want to be neutral, non-confrontational, and almost establish a rapport with the witness, right? If I can establish some kind of connection with this witness, right, maybe we both have on the same tie or something, right? And I'll get up and I'll make a joke. Unless talking like it's a real serious case where it's just inappropriate. You get up and I'll say, oh, looks like we have on the same tie. That's all you have to say. And suddenly, you and that person now share something, right? We share something, we have something in common. I can build a rapport. And so I can ask you questions that are neutral in terms of my tone, and then non-confrontational, just to bring out facts, right? And if I'm non-confrontational, and I've built some kind of rapport with you, we have some kind of connection, you as the witness are going to be more than willing to talk, right? Because again, it's different from mock trial. In mock trial, everyone's prepared, right? Nobody's really nervous. Nothing's going to get won or lost. You know, it's fake, right? It's mock. Real trial, witnesses are scared, right? So we talked about how witnesses are scared on direct, right? Sometimes you have to hold their hand. They're even more scared on cross because suddenly a guy or the lady who was holding their hand, she has to sit down and be quiet. and now you're gonna do things, right? Like that's the reaction of like, you're gonna do something. So if I can get them to calm down, get them to a neutral place, and just say, okay, so you worked at Weis Markets, correct? And you were working at Weis Markets on the 12th, right? And instead of saying right, they might go off on a tangent. But I've already established a rapport, we're neutral. They might say, yeah, July 12th, I was working at the front counter and I was waiting on customers. I was working in the tobacco aisle and I saw Mrs. Doe approach. Well, he's just done you a huge favor, right? Because you don't have to go through all that crap, but you're going to. So you're gonna say, okay, let me break this just so I understand, right? So again, it's on me. I understand. So you said you were working that day, right? Yes. And you were working the tobacco aisle, right? That's what you said? Yes. And you said that day you saw Mrs. Doe in line at the tobacco aisle. Is that true? Yeah, absolutely. She comes in pretty regularly, right? And they might just go off on another tangent. Well, you follow it up, right? So you get some of that repetition going. But as long as I'm not threatening you, I'm not attacking you, you're going to talk to me, right? Doesn't matter. You're going to talk to me. If I'm attacking you, like we get into, like, think about your personal relationships, right? Let's say you get into a fight with your significant other. If you approach it in a calm, neutral tone, right? We're saying like, look, we're having this problem, right? We need to fix it. Versus, you left the door open again, didn't you? Which one am I going to respond to, right? If I'm being attacked, I'm shutting down. And if the jury sees me attacking this person who's probably scared for their life, even if it's not a big deal, just like hammering at them and like I'm a shark at them, the jury's not going to like me, right? So I'm not going to get information and the jury's not going to like me. So that's our first goal, is getting that information. It's good for our side. We want to bring up good points for our side and minimize the bad points, right? Obvious. So the second thing what we want to do in cross-examination, and be careful here, is attack or limit parts of the witness's testimony. Right, this will just depend on the witness. Some witnesses, like, there's no reason for me to badger the shop clerk, right? He doesn't have a dog in the fight. Ones that do have a dog in the fight, I have to handle with special care, right? And this is true with anyone that even if they don't have a dog in the fight, they have some kind of conflicting testimony that makes us count or cast doubt upon their testimony. Suddenly, my hands are full now, all right? Because now we're playing the game of chess. This is the part we're playing the game of chess. So what you want to do is you want to consider attacking specific parts of the witness's testimony. And this includes exposing weaknesses in the witness's perception, memory, ability to recount the events. Right? So just beginning with that, it involves bringing out important prior inconsistent statements that contradict what witnesses said on direct, showing the witness's testimony is at odds with other evidence, the witness is confused, mistaken, forgotten, or the witness has intentionally changed their testimony. And this is where we have to be careful, because somebody has a dog in the fight. Or maybe they don't have a dog in the fight. Maybe they just saw Mrs. Doe go into the grocery store. It's just a little man who saw Mrs. Doe go into the grocery store. And I want to show that Mrs. Doe didn't go in the grocery store, right? That's the whole theory of my case, is she didn't have any tobacco on her. Yes, she smokes, but she didn't have any tobacco on her. I'm cross-examining this guy, and I want him to basically say, no, she didn't go in the grocery store. We play on people's weaknesses, right? So if we're talking to somebody who's older, As you grow older, you start to forget things. Things are not as important. I'm going to start playing things on your memory, right? I'm going to start testing your memory for the jury to show, look, jury, this person has a really bad memory, or this person has a really bad sight, or whatever it is. But again, I'm not doing it in a way that I'm attacking the person, because there's no reason to attack, but do it in such a way that you're showing and having them admit that they might just be wrong, right? Have them admit that they're wrong. So it's unfortunate, but if you ever get a case where somebody has Parkinson's disease, which for me is a really upsetting thing, is my father showing signs of early onset of Parkinson's, searching for words constantly, things like that. It's rough. And we're just at the beginning, right? So Parkinson's, or not Parkinson's, Alzheimer's. Parkinson's is a whole other thing. Alzheimer's disease, sorry. Showing early signs of Alzheimer's. If you get a witness who has Alzheimer's, you're walking into a bear trap, right? Because we, as people, right, instinctually feel bad for that person, right? That person, I mean, on the scan, they're scared, but they have Alzheimer's. Maybe they remember the event perfectly, right? Maybe they do. It's my job to get up there and confuse them, which is really, really difficult, right? Especially if you live with somebody or have some relation to somebody who has the same disease. Because you can relate, and you're gonna wanna relate to them, right? But you're also trying to prove to the jury that they didn't see what they said they saw, or they don't remember, right? So my tone with them should not be like I'm talking to a child, because they're adults, and we want to see them as adults. But again, it's very kind of that kind of monotone, low voice, in a slow fashion, so the person can understand. That shows I'm caring, I understand, like I'm sorry for what you're going through. But then we'll start asking them questions from the direct examination that either didn't make sense, or that I've altered in such a way that they start to become confused, right? And they say something that they didn't say before, or they don't say something they said before. And I pull out the affidavit and I said, well, you know, you testified and under oath and you gave this, right? This is what you said you saw. So which one's the right version? Just help me understand. Which one's the correct version? What you just said or what you wrote down? They have Alzheimer's, they'll start to cry, right? Because chances are they're not going to remember a damn thing, depending on how advanced the disease is. And that hurts. I mean, it hurts them physically. Like just destroys their insides. And you know that jury is going to be really angry at you, right? Because you just made somebody with Alzheimer's disease cry. That's when you have to kind of soften the blow. And the person goes, ugh, starts to freak out. Like, I don't. I'm like, oh, Mr. Taylor, it's fine. It's fine. You know, do you need a break to get a drink of water? Anything along those lines? You know, don't beat yourself up. It's completely fine. Right? Am I talking to him? No, I'm talking to the jury. Right? Now I'm suddenly, yeah, I did damage to him, but I'm trying to show, like, look, I had to do this. I didn't want to do this, but I have to for my client. But, you know, everything's fine. You're going to be okay. Like, it's going to be okay. Right? You're reassuring them. If you have somebody with a mental disease or defect, is what we call it in legalese, it gets rough, right? So Alzheimer's disease is a rough one to deal with. As much as I hate this term, it's still the legal terminology used. Mental retardation, so somebody with developmental disabilities. That's a hard one to do, especially depending on how, what condition that they actually have, and a number of factors that affect their mental health. They might have to have somebody up there with them, right? Like to literally hold their hand, right? Because they're that scared. I want that, like, right? I want to show the jury, like, okay, that's completely fine. Like the judge goes, are you okay with her being up there holding the person's hand? Absolutely, Your Honor. You know, and just before we begin, if we need to take a break at any point, or this becomes too much, you know, we are more than willing, you know, just to take a break, or take a 5-minute break, or whatever it is, right? So like, you're kind of selling yourself to begin with. And then you get out there and you have a conversation. You don't even acknowledge that the support person is there, unless that support person talks. That support person talks, you ask the judge for a bench conference. Bench conference is basically where you go up to the judge. You and opposing counsel go up to the judge because there's some issue, but you don't want that issue heard by the jury, right? So get up there and say, Your Honor, she just told him what to say. She's testifying for him. We agreed that she could hold his hand, but she can't testify for him. She's not on the witness list. And the judge has to basically instruct this person they can't answer questions, right? So they might, depending on the judge, they might just blanketly just say, you know, Ms. So-so, you're not permitted to speak during this portion of the proceedings. But that also might freak out the witness, right? So some judges are cold and will just do that. Some judges will say, can I see counsel and Miss so-and-so and Miss so-and-so, right, the witness and their support person in chambers. And then they'll say it, right? Again, it's away from the jury, so the jury doesn't think you're a jerk and just like tattled on them. Then they'll say it, and we come back, and I re-ask my question, but I ask it directly to this person, right? Not acknowledging the support person is there. And I'm having a conversation, right? And as long as it's not like a really serious case, it's okay to smile, right? People with developmental disabilities pick up on body language like nothing else, right? So if you're calm, cool, collected, that's awesome. If you smile, they're gonna smile, right? Like they're gonna work with you. And yeah, if they have developmental disability, they're probably not going to conceptualize the fact that you're trying to make them look bad, right? Or you're trying to get facts that they shouldn't tell from them, right? So it's a rough game to play. Now that's very rare that it occurs, right? Most of the time we have lucid witnesses, but human memory is terrible. Human memory is absolutely terrible. There's been several studies, and if you take psychology, you'll hear about one. There's this famous professor, and she taught criminal justice, right? Every day, or every time on the first day of class, she would be running late. Well, she would go into the classroom when everybody was there, right? Not say anything, but you know, people would notice, like, oh, the professors walked in, and they keep talking because, you know, we haven't begun the lecture yet. So she comes a little early. She puts her purse on the podium, and either checks her watch or checks her phone and walks out the door. Then she had a graduate assistant of hers run into the room, grab the purse, and run out. As soon as that person ran out, she came back in. And she said, write down exactly what you saw. And she has them write down paper what they saw. And then she starts reading the papers aloud. I saw a 4'2" black man, right? And he was wearing red high tops. I saw a 5'10" white man. He was in flip-flops, right? In kind of going down the line. Like, human perception and memory is terrible. I mean, it's absolutely terrible. So this is where you can really exploit that, right? And again, unless you have somebody who has developmental disability or some kind of mental disease or defect, you're going to be able to exploit that in a way that looks like you weren't lying, because unless I want you to be lying, like unless I'm trying to prove to the jury that you're just making crap up. But you're trying to get them to acknowledge they misremembered something, right? Because suddenly, oh, you're right. You're right. That's what I said. I forgot. You know, like I misremembered. That's a whole lot different. Again, even when I'm questioning somebody, then you're a liar, right? Because then I'm on the attack. But oh yeah, I forgot. Well, shit, we all do that, right? Like, think about it. You take an exam, you get an exam back, and you knew the answer, and you're like, oh, I forgot, right? It happens. Happens to all of us. Like, I have my Google Calendar. Like, I live by my calendar, and I still miss stuff, right? And it's just like, I forgot. Human memory is terrible. So, to that end, you can start to exploit and kind of push the fact that, hey, they misremembered, or if they're lying and you want to show they're lying, then you can get aggressive. But your tone should generally match to theirs. All right, if they start to raise their voice and you're trying to prove that they're lying, you raise your voice. If, let's say, they lower their voice, you should lower yours. Right, you need to match. So that way it's not like in a personal attack. We're just having a back and forth duel, which is what the jury wanted to see in the first place. And then the final thing you would do in a cross-examination is attack the witness himself. Right? So we're trying to get other like misrememberings and things like that. Now we're talking about this witness. Right? And I want to know, and you should know before you go to court, does this witness have a bias? Does this witness have an interest? Does this witness have a motive to testify in a certain way? Right? So even if you call somebody who's not a party to the lawsuit or the criminal proceedings, right? You don't call the defendant and you don't call the plaintiff. You call somebody else. All right? And let's say there was a guy got stabbed in an alley next to a secondhand store, right? Well, you have the defendant, and then you have the person who got stabbed, the victim. You're going to talk to the victim, absolutely. Defendant doesn't have to testify. They have Fifth Amendment privilege. You're never going to talk to the defendant if they have a smart attorney. But they might call, or you might call, depending on your side, they might call the owner of that secondhand store, right? And they say, okay, what'd you see? Blah, 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 can go through it. Right? And they're just going to walk through what they saw. I'm saying, so you said you saw the attack and you stopped it, right? Because you said it was very, very rare that something like this occurs. Well, isn't that not true? Doesn't this occur fairly frequently? We all know that this is a bad area of town, right? So trying to identify one person when you were in the back of the shop? Are you trying to save your shop's reputation? Are you trying to promote your shop? Right, these are questions that theoretically I should ask myself before they come out of my mouth. But you're attacking that person, right? But you're doing it, again, in such a way where you don't seem too combative, but you seem like a reasonable human being. To that end, I'll say this. You know, those are the big three, right, that you want to do on cross. You can control witnesses fairly well. And it's mock trial, it's different, but in regular trials, if you say a yes/no question, they're going to answer yes or no, unless they really feel the need to elaborate. And if they feel the need to elaborate and it's bad for you, cut them off. You can stop them mid-sentence. as long as they've answered your question, right? Or you can just re-ask your question, or you can object to the judge and say, Your Honor, the witness is being unresponsive. I asked a yes or no question, and now he's talking about a deli. Right? Like the judge is gonna say, yeah, you have to answer the question. So I can cut him off, I can do whatever. And once I do that once, it'll be yes or no the rest of the time, right? So you can control them. Witnesses on cross-examination is fun, right? Because it's so much strategy. Direct examination, you go up there, the witness is the star, the witness is prepped, they're on your side. Cross-examination, they hate your guts from the minute you stand up. Your goal is to change their opinion, but not their opinion necessarily, the jury's opinion, right? So they're kind of linked in that interest. So again, this has still been called impeachment material, and we'll talk about what impeachment looks like and how you impeach a witness in a later class. So there's anything else I want to get to? Okay, so my last talking point. So when you're doing a cross-examination, keep it simple. Right? Don't go into like crazy detail, because then people are like, you're asking too much, right? Like, no, keep it simple, right? Keep it simple, stupid. And keep it realistic, right? So, think about the shop owner, right, that we talked about, and we're like, oh, maybe they're trying to make their shop look good, or this is a televised trial, so they're trying to get people to go to their shop. But the shop owner just says, yeah, I saw the murder, and that's it, doesn't testify about anything else. Is it realistic to be like, you're trying to promote your shop? Probably not, no. All right, so you have to be realistic in what you're trying to get out. So what you really want to do is cross-examination is not hitting home runs, right? So we all see on TV where the cross-examining attorney is questioning this person, and suddenly she goes, I killed him, right? I killed him. That doesn't happen, right? Because that is a home run question. If you know anything about baseball, like, so I grew up in Missouri during the time of Mark McGwire and Sammy Sosa, right? Now both very disgraced, but at the time, Mark McGwire and Sammy Sosa, they were competing for the national home run title, right? Like the world record in home runs. That year, the St. Louis Cardinals, guess who their worst player was when it came to striking out? Mark McGwire. He ultimately won the title, but he struck out the most. Same is true in law. All right, if you try to go for that home run question, you're going to strike out. Right? Maybe you'll get it once in a lifetime, but you most likely are going to strike out. And you're going to look like a fool. You're going to look like a jackass. So cross-examinations are about hitting singles and doubles, right? Singles and doubles. Just little hits here and there that help you progress through the bases to get home. So what you want to do is you want to pick the 2 to 4 best points that you can safely raise during a cross-examination, right? And you have to ask yourself and be aware that too many points can overload the jury with information, right? Because they sit here all day and hear all this other stuff. I want to make 2 or 3 points and then sit down. Right? I don't want to stand up there for 3 hours. A good test when asking a cross-examination question is, will I be talking about this in the closing arguments? If yes, then pursue it. If no, there's no reason to go after it. Right? It's not important enough to develop over cross-examination. So I will give you the last thought here is one that gets taught at every law school in the country. It's true on direct examination as well, but it's especially true on cross-examination. Never ask a question that you don't already know the answer to. Right? Never ask a question that you don't already know the answer to. And fun fact, this works like in life as well, not just in the courtroom. Because if you go up there and you're like, I don't know what they're going to say, they could completely take your case in one sentence, right? So again, never ask a question that you don't know the answer to. Questions, comments, concerns? All right. In that case, I will stop the show.